of the Minister of Interior, as it were then. This was a case that was keenly followed by the public, and the circumstances of the arrests applies almost mutatis mutandis with the circumstances under the arrest of our client, where they were both dragged out of an aeroplane. Your Honor, Mr. Owino has stated the statutes which he relies on, and I wish to refer to the judgment by the court in that case. Your Honor, the court was very clear. Yes. Full citation. Your Honor, this is Constitutional Petition number 51 of 2018. That is Miguna versus... Yeah. Yes. So, Your Honor, if you have a look at that case, Your Honor, the judge then, now elevated to the Court of Appeal, Justice Udunga, recognized the dictates of the preamble, where it states that it recognizes the aspirations of Kenyans for a government based on the essential values of human rights, equality, freedom, democracy, social justice, and more importantly, the rule of law. Justice Odunga says, in other words, the people are clear in promulgating this constitution that the constitution is the supreme law of the republic and binds all person and state organs at both levels of government. At Article 2.1, the people meant that no person may claim or exercise state authority except as authorized under the Constitution. Counsel Owino has made reference to Article 28 on human dignity. I'd go again and also look at the rights of an accused person under Article 49 of the Constitution. And I will belabor the point that from a cursory look of the charge, it is clear that whoever instructed the arrest was insistent on what is now infamously called the Kamata Friday modus operandi, where the arrest is meant to detain the accused person past the 24-hour rule. Your Honor, despite pleading by counsel for the accused, for the police to issue a police bond or police cash bail to the arrest person, they declined that invitation, prompting the accused person to spend close to now 72 hours behind police custody. And that is why we are before you today, pleading to this court to release the accused person on a bail of personal cognizance. And why are we saying personal cognizance, Your Honor? Not long ago, as I sit, because I don't want to take much of the time, we initially appeared before your sister, Honorable Dolphina Alego, and this was the maiden appearance of Honorable Owino when he was admitted to the bar, where in criminal miscellaneous application E2362 of 2025, the DCI application to withhold one Suleiman Wanjau Bilali and Robert Otiti Elwak for 30 days pending further investigations. Your Honor, why I'm making reference to this particular case is that what is unique to this case, and I can apply to this case, is that the two respondents, as they were then, were citizens of great holding in this public. Suleiman Wanjau Bilali then was an Olympic gold medalist in the 2000 Sydney Olympics. Robert Otiti Elwak is former Harambee Stars captain who scored 9 goals when Kenya beat Somali 12-0. So there is a way and manner in which the criminal justice system has been crafted to now taint this image of Kenyans who have done extraordinary things for this public and things of public interest to help the public good and taint their image and their good work. Mr. Omondi has made us laugh, has made the nation laugh. So, Your Honor, we will be asking this Honorable Court to consider our application for bail, and for that only reason, release him on bail of personal cognizance. Your Honor, I rest my case. That's it.
Your Honor, just add one thing in a minute. My name is Nahorenya. Nahorenya. Your Honor, we want to urge this Honorable Court to resist the temptation of escorting the prosecution to realize ulterior motive. The sole purpose why Erick Omondi is before this Honorable Court is clearly for him to be punished. Your Honor, I want to urge this court to take notice of the state of affairs in this country. It is very clear that the prosecution has engaged in a fishing spree. Your Honor, given that the right of innocence is guaranteed to the accused person, that right escorts the accused person from now to the very end of determination. Finally, Your Honor, the fact that we made effort for him to be admitted to bond, police bond, and that was denied, Your Honor, we submit that the rights of the accused person now were being subverted. And for that reason, the prosecution has already realized its ulterior motive, objective of pretrial detention. We submit, Your Honor, that for that reason, the accused person has already suffered. His rights have already been subverted. We plead with this Honorable Court that you admit him to a free bond. I submit.
Good morning. Nurdin is my name. Yeah, Nurdin. When I'm seeking the release of person's cognizance, we would like to take court attention to one matter. He was meant to attend a function where he was meant to be paid. Now that particular function is not going to be paid, he had contractual obligations. He was attending a function, an event, as an entertainer that he is, where he was meant to be paid. Now that particular payment will not be done, he has lost income. That particular ticket that he had paid to go, because he was in a plane where he was landed out of the plane, he was not very fast. So, the fortunate thing is that he could have been summoned instead of how they went for Rambo movie to get him from the plane. Mark you, all those individuals in the plane are potential clients to him as entertainment. So who is meant to contract him again if they see him as a criminal? Yeah. So we humbly pray that he be released so that he can actually go ahead and reschedule his contract obligations with a particular client, and we pray for him to be released on public license, knowing that he cannot wait. He's well known. Look at the courtroom behind you. And all of them are waiting for him outside at the end of the day. Because as Council of Mango says, he runs something called Sisi, where he assists Kenyans. Sisi kwa Sisi, where he assists Kenyans. Those who are unable to pay school fees, those who are unable to even to attend court matters and pay. He comes here to assist Kenyans. So I believe he's a good citizen. And let us not allow the prosecution, seeing that the mood of the prosecutor, I don't think they will be opposed to pay. So you can move to the issue where you can order an extempore bail and he can go home with us.
Your Honor, I'll be brief. Ms. Martina. Yes, Your Honor, we are firm believers that the judiciary is independent. That is what the law provides, and that should be. And it should be independent from orders above. Contrary to what the police are practicing, this is a court of law. Independence should be integral in the decision making. Your Honor, the main essence of bail is primarily to secure the attendance of an accused person in court. The accused person here, Mr. Erick Omondi, does undertake that he will be present as and when needed in court. Therefore, pretrial detention will be a waste of resources and is not necessary, and should be as a matter of last resort. It is not a secret that this is a man of the people. However, he has become an enemy to the state. But that we can argue another day. But as of today, Your Honor, there is absolutely no justification or no compelling reasons that have been fashioned by the prosecutor to deny Mr. Omondi bail. Therefore, ours is to pray that you grant him a free bond, personal cognizance, as my colleagues have submitted before you, and that is what I wish to submit.
Jonah, I guess I'll conclude.
Mr. Kilonzo? Your Honor, in agreement with the sentiments of my fellow counsels, I'd like to point out that the Oxford Dictionary defines compelling reasons for something so grieving, so strong, so convincing, and undeniable. Therefore, if the prosecution is to oppose bail, they only need to demonstrate to this court through evidence that our client, they cannot be able to trace our client, being that he is a public personality, and that it is very convincing. Mr. Erick Omondi shall not attend to the summons of this court, shall not attend, and shall not comply with the directions of this court. And the general principles that govern the right of bail and bond, one of them being that the balance of the rights of the accused person and the interest of justice and consideration of the rights of the victim. The prosecution is therefore mandated to demonstrate to this court that justice shall be hindered if our client is not released on bail. That is all.
Your Honor, I'll conclude.
Remind me again.
My name is Omondi. I appear today by. I think Mr. Bobo had something else to say, to add. One thing, 1 minute.
Yeah, just 1 minute, Your Honor. Something has just crossed my mind, that the charge is obstruction of motor vehicles in town. Your Honor, if you are generous enough, if you can give us warrant of arrest to arrest the said BCI officers who went to JKIA to obstruct a plane while it was almost taking off, Your Honor. We will not need the BCI to make the arrest. We have enough citizens here. We can go and make citizens arrest. Thank you.
Thank you, Your Honor. My submissions are, I would not want to lose track on the bail and bond policy issues. One, Erick has a humble abode within Nairobi. They know where to find him. Erick is not at flight risk. Erick has demonstrated times before that he has attended court religiously in other matters, and that is public knowledge, so he will attend to this court. I agree with my colleagues in the end that if for anything, please allow him on free bond. Second last issue, yes. Second last issue is something very simple. I'm calling it circumvention of Article 49(1), the right for the accused person to be brought to court within 24 hours. You know, this is a person they would have summoned on Monday, summoned on Tuesday, summoned on Wednesday, and Thursday. But they strategize to arrest him on a Friday. The goal is to circumvent the 24-hour rule. This circumvention, I can equate it to tax evasion, where somebody decides he's not going to pay tax, but use different mechanisms to evade the tax. It is criminal. Now, this form of circumvention that the DCI and the prosecution have done is in itself unconstitutional because it has led to illegal detention of Erick Omondi. We are starting this game 1-0 down. Erick has been illegally detained. His rights have been trampled upon. Today, we plead with you to raise the game to either 1-1 or 2-1. That is, allowing your free bail. We will come before you and defend the matter accordingly. Unless any of us, because I know you are so many of our colleagues, has something else to say, we will allow you.
Good morning. After all is said and done, my name is Pius Oyo. Yeah, we pray that you deliver the ruling extempore so that our client can go and meet his contractual obligations. I'm reminded he should also go and question. That is all, you know.
Your Honor, the prosecution is not opposed to the accused person being granted cash bail or bond. I pray that this court will be guided by the bail and bond policy. On the issue of infringement of the accused rights, I'm informed that he had previously been summoned by a phone call by the investigation officer and he failed to appear severally. Efforts to trace him were futile, leading to his travel documents being flagged, which led to his subsequent arrest at the airport. I'm informed that his boarding time was 12:20 and he had not yet boarded the plane. He was arrested at the ground, so he had not yet boarded the plane. Your Honor, issues of constitutional infringements of accused constitutional rights and rights are issues that can be handled before the High Court, Your Honor. I repeat that we are not opposed to the granting of cash bail or bond, but not personal bond.
As we proceed, one thing that is important, his mobile phones were confiscated again for crime of I don't know why his phones were confiscated.